Bad facts make bad law. You got to understand that there's basically two types of challenges when we're talking about challenges to gun laws in today's age. One comes from fantastic groups like Gun Owners of America, Firearms Policy Coalition, National Association for Gun Rights, Second Amendment Foundation, and many others, Wisconsin Institute for Law and Liberty being just one to local name drop as a Wisconsin boy. Those groups are being careful to make sure that they've got fantastic fact patterns to challenge law so that when judges look at things, they're not looking at bad people doing bad stuff. They're looking at good people who are just trying to protect themselves. That's the good kind of challenge. We're not talking about that kind of challenge today. We're talking about the other kind of challenge. So guys, let's get into it. All right, so we're talking about the other kind of challenge. That's the kind that we don't like to see. This is typically coming from folks who are doing bad things with bad records, and they've got a defense attorney who's basically, for one reason or another, best case scenario, zealously advocating on behalf of their client. Worst case scenario, they're anti-gun, and they know that they are probably going to be actively moving the needle against the Second Amendment. Well, that's what we're going into. The roadmap for today is we're going to go through the facts of the case, we're going to go through the motion to dismiss, then we're going to go through the ruling on that motion to dismiss, and then where this might be going in the near future. So we're talking about the case of Matthew Kittson, who back on January 10th, 2020 in Oregon, decided to do something stupid. There's an ATF undercover agent learned that Mr. Kittson was allegedly trying to sell a machine gun, a Russian PPSH-41 in 7.62 by 25 Tokarov. Over a series of recorded calls, one where Mr. Kittson reportedly claimed if you just push the switch, quote, it goes from single shot to full auto, end quote, and it will, quote, spit like 1,200 to 1,400 rounds a minute, end quote. Ultimately, the agent reportedly paid Mr. Kittson $8,000 for the PPSH-41 as part of a sting, ending with the predictable arrest and indictment, which brings us to the case. But wait, it gets worse. It's like the reverse ShamWow guy or Billy Mays or any of those guys.
You'll be saying wow every time you use this towel.
Mr. Kittson also has a bunch of convictions, and no, they're not for light things. Back in 1980, Mr. Kittson was convicted for robbery in the first degree. Back in 1987, felon in possession of firearm. 1988, and again, some sort of felon in possession of firearm. 1988, again, attempted murder with a firearm, and 1988, manslaughter. I don't know anything other than what I just gave you, but again, you can kind of see where we're going into bad facts make bad law. So in June of 2023, there was basically a Second Amendment motion that was filed to dismiss this case that doesn't challenge the facts because maybe they weren't challengeable, all being recorded and I'm sure carefully admissible and so forth, though sometimes you run into things as a defense attorney, but more so challenging basically the constitutionality of the, hey, machine guns are illegal. Why? Because the Second Amendment covers bearable arms. That is what courts have focused on. So if you're a destructive device enthusiast, don't throw your shade and angry arguments at me. What is a bearable arm? Well, in a nutshell, the sort of weapon that you would bring to a militia muster to protect your community. Something that's commonplace, something that's ordinary, and is commonly used for law-abiding purposes, so say the courts. So by doing this, it would seem that courts are trying to carve out basically crew-served weapons, though there is certainly some history of that being entirely legal and well within the American tradition, and accordingly legal perhaps within the Brune decision. More on that in another video. If you want it, let me know in the comment section below as well. For now, we press on with bearable weapons. And we do that because a PPSH-41, like an M16, is absolutely and non-negotiably a bearable arm. The fact that the weapon is a full automatic machine gun doesn't change how bearable it is. It was designed for Soviet troops to fight the Nazi invasion back in World War II. It's a little clunky and heavy by today's modern standards, but they were extremely reliable and easily portable and carryable. So absolutely a bearable arm, at least so it seems on its surface. Now, thanks to the National Firearms Act, in concert with the Hughes Amendment, there is no legal method for a civilian to purchase, possess, or transfer a machine gun made on or after May 19th in 1986, subject of a different video. You can, however, in most states, still lawfully purchase what are known as pre-86 or transferables and things like that. We're basically talking about machine guns that were properly registered prior to May of 1986. Now, we've done a number of videos on the subject, but in brief, there are somewhere around 175,000 of these machine guns that are in existence. And notably, since the registry, none of them have been used to commit a crime outside of some off-duty police officers misusing them. So keep that in mind the next time someone says guns cause crime. Well, apparently machine guns don't. So guys, I'm trying to keep this video a little bit on the shorter side. If you want to see me do a deep dive about machine gun law, hit that like button. Let me know in the comment section below. If there's enough of you out there who want to see that happen, I'd be happy to do so. If it's just too nerdy for YouTube, I get it. I'll keep the information up here for better or worse, depending upon who you are, I guess. Now back to the video. The motion to dismiss sums itself up like this from the motion itself, quote, "The preliminary issue really is that straightforward. The Second Amendment protects the right to keep and bear arms. Automatic rifles are arms. Therefore, they are protected by the Second Amendment. It falls on the government to show that, nonetheless, banning automatic weapons fits within America's historical tradition of arms regulation," end quote. So how did the government respond? The government basically gets into the argument of, look, the Second Amendment's not an unlimited right, citing Heller at page 627. It does not allow every single person to keep and carry any weapon whatsoever in any manner whatsoever for whatever purposes. That's not me. I'm reading from Heller. The government argues that the possession of machine guns as a course of conduct falls outside the scope of the Second Amendment. The Supreme Court held that certain types of firearms can fall outside the scope of the right to bear arms. And then they cite to the 1939 Miller decision, which basically upholds the National Firearms Act in 1934, which prohibited, in that case, an individual from being in possession of a short-barrel shotgun, contrary to the National Firearms Act. Now, modern regulation machine gun possession imposes a comparable burden on the right to bear arms as the historical burden against possession of dangerous and unusual weapons. So if you look at a lot of the case law, subject of another video, you'll see that there's exceptions where, hey, bearable arms presumptively are protected by the Second Amendment if they're in common use, and they're in common use by ordinary citizens for common lawful ordinary purposes, such as self-defense, among other things. Okay. However, there's an exception for dangerous and unusual weapons that the Supreme Court has left. I have not left that comment section. The Supreme Court has left that open. And here's the crux of the government argument. They basically say, look, the fact that the Hughes Amendment, the fact that the National Firearms Act was all passed 100 plus years after the passage of the Second Amendment is irrelevant. It doesn't matter when the law was passed. It matters that the law, whenever it was passed, prescribes conduct, prohibits conduct, in other words, that was similarly prescribed at the time of the Second Amendment. Not exactly true because it's really common use, but let's stay on this train for this case. So that's the arguments from both sides. The defense saying, look, show me the historical regulation, and the prosecution saying, look, effectively, these are dangerous and unusual weapons, and those are allowed to be regulated. They're both kind of wrong on how they're arguing this, but that's all subject to another video. On August 7th, 2023, the court ruled, predictably, denying the motion. The court basically starts with the Bruin test. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Bruin's step one is what's called as a threshold question, and this has been a huge thing that the anti-gunners have been using to basically try to uphold gun laws and regulation. Step one basically requires a textual analysis to figure out whether the challenger is part of the people who the Second Amendment protects, whether the weapon at issue is in common use today for self-defense, and whether the proposed course of conduct falls within the Second Amendment. Now, the Heller court struck down a law prohibiting handgun possession, but noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. Although Heller did not specify the types of weapons that qualify as dangerous and unusual, the Supreme Court suggested that it would be startling for a Second Amendment to protect machine guns. That's coming from this court denying the motion, citing Heller at 624. Not me saying that. Relying on Heller, the Ninth Circuit in a later case held that machine guns are not protected by the Second Amendment because they qualify as, quote, dangerous and unusual weapons that are not typically possessed by law-abiding citizens for lawful purposes. End quote. Then the court basically wraps it up by taking a gander around the room at what the other courts have been doing since Heller, since McDonald, since Bruin, and then basically jumps on the winning team that machine guns are not part of the Second Amendment because that's what everyone else has been doing. So you see this momentum push. I'm very interested in doing a whole video where I do a deep dive on machine gun law, not NFA law, not short barrel rifle law, short barrel shotgun law, or anything else, just machine gun law. If you want to see me do that, let me know, and I'll see if I can fast track that and get it going. But otherwise, this is unfortunately just another brick in the wall for anti-machine gun rulings. Now, this case has been appealed to the Ninth Circuit Court of Appeals, but even if it goes there, realistically, it's not going to change anything. And even if it goes beyond that up to the Supreme Court, well, I'm not super optimistic, but again, I've got a lot of reasons as to why. Let me know, and I'm happy to make another video if there's enough of you out there who are interested in this kind of nerdy Second Amendment talk. Otherwise, our quote of the day to reward those of you who made it this far comes from Seneca, quote, "No man is more unhappy than he who never faces adversity, for he is not permitted to prove himself," end quote. We'll see if Second Amendment and machine guns have a chance to prove themselves in the Supreme Court, who have already taken an astounding number of Second Amendment cases already in this term. Let me know what you think about all that. Don't forget to hit that like button, and I'll see you in the next video. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.